Hey, happy Wednesday, everybody. My name's Beth Ann Lennon, and I am going to kick us off with the second of our NLRB specific presentations or webinars as part of this program. And for those of you who are joining us for the second time, welcome back. And for those of you, this is your first one, welcome. So today's topic is how employers may need to adjust their best practices under Trump's NLRB. So we're going to take this opportunity. We've got lots of great content for you to do a little bit more of a deep dive on some of the things that the prior board implemented that we anticipate might have implications for your day-to-day practices as an employer here in the United States. So once again, welcome to this presentation. This one is going to be a little bit more interactive than some of the other ones. And part of that is we are going to be starting with polls on each of the topics to kind of get a little bit more input from you guys and make you think about the topics that we're talking about. So let's go ahead and dive right into that first topic, which is going to be our captive audience meetings, and start with our very first poll question. So this question, do you believe the government should be able to restrict what you discuss with your employees? And the options, yes, no, or I prefer not to discuss things with my employees. So we'll give you a chance to answer that question. Right. So let's see. We have a pretty good mix. I love I prefer not to discuss things with my employees. We have at least 5 employers out there who don't want to discuss anything with their employees, and I'll take it. But a good mix, and definitely a significant number of you that say, no, it's not the government's role to be restricting what an employer is discussing with their employees. A really good frame of mind to have when we're talking about this first topic. So let's go on to the first slide on captive audience meetings, which will help us understand why we're here and why this is part of what we're starting our best practices and what you should be thinking about presentation. So just big picture for those of you who've been paying attention, since 1948, when the Babcock and Wilcox case in front of the board was issued, the standard was, quote, an employer is free to hold mandatory meetings on work time to express its views to employees about unionization. However, that concept came under attack during the Biden administration, including when the prior general counsel issued a memo back in 2022 where she expressly said that she was going to seek a board case that would allow the overturning of Babcock and Wilcox. Now, it did take her more than 2 years to get the result that she was looking for, but that actually came to fruition in November of last year when the Amazon.com Services LLC decision was issued by the board. Now, the concept here is that there should be, according to these board decisions and the general counsel's memo, is that there should be some kind of restrictions on when and whether you can speak with your employees, especially when the topic is unionization. So in the Amazon.com Services LLC case, Babcock and Wilcox was set aside, and the board determined that compelling employees on pain of discipline or discharge to attend a meeting during which the employer expresses its views concerning unionization is a violation of Section 81A of the NLRA, right? So you're going to face an unfair labor practice charge if you have meetings in which your opinion concerning unionization is conveyed to your employees. This was a complete 180 from where we were before. Now, I will also say, though, it didn't go quite as far as the GC had hoped. Now, the GC's memo actually suggested that supervisors speaking with employees in one-on-one conversations in the hallway would just be just as problematic as having these meetings. So the reason that the board held that this was impermissible was this concept that an employer has so much power that an employee actually doesn't have free choice regarding expressing their opinions if they are compelled to participate in these meetings and listen to the employer's opinion on the topic. So if we can go to the right, the next slide, we can talk about exactly what was buried in this opinion and the current state of the law, by the way, as of today. Although again, this is one of those ones we anticipate might be changing quite soon. Okay, so what is a captive audience meeting? What do these opinions say you can and cannot do? So according to this board decision issued late last year, if under all of the circumstances, an employee could reasonably conclude that attendance at the meeting is required as part of their job duties, or could reasonably conclude that their failure to attend or remain at the meeting could subject them to discharge, discipline, or any other adverse consequence. This is what we're talking about when we're talking about a captive audience meeting, right? And this next one I had to put on there because I think practically speaking, most employers are probably doing things like this and not even realizing they might be running afoul of what the board's current opinion is on this particular topic. Attendance at a meeting that is included on an employee's work schedule as communicated by a supervisor, manager, or other agent of the employer will be considered to be compelled. So for example, if you have a practice of sending out electronic invitations to your meetings that then show up on your Outlook calendar, this is the kind of thing where the board has said this is a compelled meeting. And this, according to, again, the GC, should include restrictions on your ability to have group meetings and impromptu one-on-one meetings, which again, from just practical advice to employers, that means your supervisors and managers could be getting you in trouble under these guidance without even understanding the restrictions on their ability to have communications with their employees. Now, in order to be the type of captive audience meeting that is intended to be captured by these opinions, it is supposed to be a meeting where the topic of the meeting is, quote, concerning their exercise of Section 7 rights. But again, not to be the Debbie Downer in the room, but I will say that that is much broader than you would think. For example, the example that the former GC gave was that, quote, this rule would not apply where employers require employees to attend meetings on subjects other than their exercise of Section 7 rights, such as meetings for job training or safety instructions. But it would apply, for example, if the employer uses the meeting to dissuade employees from acting together to improve job training or safety. I will put it out there that this is a very slippery slope that was very difficult for employers to actually comply with or not run the risk that anytime they're trying to communicate with their employees about a variety of topics that they might be in trouble under the current standard as created under the prior administration. So let's look at how the Biden administration's board really said, no, this isn't a problem as long as employers do X. Can we go to the safe harbor slide, please? Okay, so under the current standard, which we do anticipate will be changing quite soon, you're still able to have these meetings if in advance of the meeting, the employer informs their employees that the employer intends to express its views on unionization at the meetings, that attendance is voluntary, that no discipline, discharge, or other adverse consequences for failing to attend or decide to leave the meeting, and that no attendance records will be kept. Again, every single time you have a meeting with your employees, it can't be mandatory and it can't be done without any of these if there's a possibility that somebody's Section 7 rights, including but not limited to the right to unionization, is discussed at that meeting. Obviously, very difficult to comply with, but they say as long as you do this, you can still have those meetings. So I'm going to take this opportunity really quickly to highlight the fact that we do have a Q&A box down at the bottom of the page. Again, this is our presentation that is intended to have great audience participation, and we've left time for Q&A at the end. Why do I highlight that now? Because if you have seen these first 3 slides and don't have any questions, I would be surprised, because this is the kind of thing that makes a smart employer ask a lot of questions. How do we possibly comply with this? So if you have any questions as we come through any of these topics, feel free to put those in the Q&A and we'll make sure we address those at the end. So if we can go to the next slide, I will highlight that up to this point, what I have talked about is the standard when the new administration took over, as established by the prior administration or the board under the prior administration. What we promised you today was a peek into what the change in administration actually means in relation to all of these best practices and what's expected of you by the board. And I do think that this is a particular area where current events and things that have been happening over the last couple weeks really highlight why we think what's expected of you right this second won't be what's expected of you for very long. So remember that GC memo 2224 was actually issued by GC Abruzzo, who was terminated by President Trump, as we talked about in our last presentation, on January 28th. There is a new acting GC, GC Cohen, who was appointed by on an interim basis on February 3rd. Now, as of sitting here right now, I double checked before I came in. This GC memo has not been rescinded by the new acting general counsel. I do expect that this is one of the ones that's kind of on the chopping block, especially because, as I highlighted earlier, the GC memo actually goes way further than even the Amazon.com Services LLC opinion did. So it's still there right now, but I do anticipate that change in administration and change in leadership at the general counsel level does put this one on the chopping block, and that's not going to be the standard moving forward. I anticipate that it will be rescinded and it may or may not be replaced by a new memo. Now, Amazon.com Services LLC was a decision that was issued by when there were 4 members of the board. Chairman McFerrin, no longer on the board. Chairman Kaplan, who is currently the chairman of the entire board. Member Prouty, who is still a member. And then member Wilcox, who was terminated by President Trump on January 28th. Now, you probably have heard about the termination of member Wilcox because it's getting a lot of news attention. It is actually quite rare for the president to terminate a member of the board, and there are some restrictions contemplated in the law for that. So, not surprisingly, member Wilcox has actually filed a lawsuit against the NLRB's current chairman, saying that that was an unlawful termination and that she should be reinstated to the board. I am positive there will be more to come on this particular topic, and there will be lots of tension around it. But for purposes of when and whether you can hold mandatory meetings with your employees, the reason I highlight this actually is outlined in the next slide. So if we can go to that. Remember, right now, there's only 2 people on the board who were there as of November of last year, not that long ago, when this decision was issued. And one of them happens to currently be the chairman, and that was Kaplan. And Kaplan actually dissented in relation to this particular opinion. And I think this dissent gives us a good roadmap of where we anticipate things will go moving forward, and really highlights why our first poll question for the day was the question that it was, which is, Kaplan says that this restriction on your ability to speak with your employees, including on work time, is, let me see, direct quote, this flagrantly unconstitutional overreach was decisively rejected by the Supreme Court as a violation of the First Amendment's guarantee of freedom of speech, right? So we know what Kaplan thinks on this, and Kaplan is one of the few people who's still sitting on the board in relation to this. Now, let's look at the next slide real quick so I can give you a little bit more practical advice as to why I don't want you to just focus on all of the shenanigans that are happening over at the board, because we really do think that this captive audience thing is likely to be decided in many jurisdictions by the states. This map highlights all of the states that have currently considered or adopted a captive audience law. And I also will highlight what the state is doing actually goes further and use more broad language than we are actually seeing from most of the proposals, even the more broad sweeping ones by the board. For example, most of these laws say that any mandatory employer-sponsored meeting that discusses religious or political matters might be a captive audience meeting that you cannot have. And they use different standards in different states. So some say if it's the primary purpose of the meeting, some say if it's just being discussed at all. And then similarly, the board really focuses, as it always does, on what you require non-supervisors to do. But many of these states actually have implemented laws that say any of your employees, including supervisors, you are restricted from having these captive audience meetings on these topics, which again, if you just think practically speaking, how you're supposed to manage your workforce with that kind of standard, it becomes very difficult to do so. So I would wonder if Taylor has any comments in relation to California, because I know she's sitting there and that is one of the states highlighted in orange here.
Thanks, Beth Ann. I was just about to jump in before you threw it over to me. So I do want to highlight that as of January 1st of this year, California employers are barred from engaging in or threatening to discharge, discriminate, retaliate against, or take any adverse action. Again, that broad language that Beth Ann was referring to. And that's in relation to you can't take any adverse action against any employee, again, broad, who declines to attend an employer-sponsored meeting or declines to participate in, receive, or listen to any employer communications regarding, quote, religious or political matters. You might be thinking, oh, okay, doesn't seem like it has anything to do with, labor organization. However, the law broadly defines political matters to include anything regarding, quote, elections for political office, political parties, legislation, regulation, and the decision to join or support any political party or political or labor organization. Even though the law is broadly drafted, there's no question that the primary target of this law, it's called SB 399, was so-called captive audience meetings about union organizing. Employer groups have criticized also the phrase employer-sponsored meetings as an attempt to ban employers from speaking out about unionization, and even so far as filing a lawsuit on New Year's Eve, believe it or not, in the Eastern District of California. The California Chamber of Commerce and the California Restaurant Association filed this lawsuit, and they contend that the law violates the company's rights to free speech and equal protection under the First and 14th Amendments. So while this law is new and in effect, there will definitely be updates depending on the outcome of this decision that we're going to keep tabs on for you all. And with that, I think Carl is up next.
Thanks, Taylor. So as many of you guys have probably guessed, I'm going to be covering independent contractor classifications. My poll question's already up for you. Before I get into the changes that we might expect from the NLRB with respect to this law, we thought it would be a good idea to get a sense for how comfortable everybody is with their organization's independent contractor classification. So I'm going to give everybody a chance to submit their answers. The question is, how confident are you that the National Labor Relations Board would uphold your organization's independent contractor classifications? All right, if we can see the results there. Okay, so we got a nice healthy mix. I love that 13% that said they have no idea that the NLRA even addresses this issue. You're definitely not alone. Lots of employers, lots of my clients don't think about this when it comes to labor law. But I think a healthy bit here, 41% of our employers are not at all confident in their classifications, which is not surprising to me at all. This is a very complicated area of the law. It's tricky to get right. Even some of the most sophisticated organizations don't get this right at all times. And so this part of the presentation may be particularly relevant to you guys. We can go ahead and close the poll and move on to the next slide here. And so move on to the next slide, please. And so by way of background, workers who are properly classified as independent contractors are not considered employees within the meaning of the National Labor Relations Act, which generally means that they're not entitled to the rights and protections of the NLRA, such as, for example, the right to unionize or to engage in collective bargaining. And so the test for who is considered an independent contractor as opposed to an employee under the NLRA has fluctuated quite a bit over the past couple of administrations. Under President Trump's first administration, a Republican-controlled majority of the NLRB, which was appointed by President Trump, issued the decision in Super Shuttle DFW. And this decision reframed the analysis by emphasizing the importance of a worker's entrepreneurial opportunity in classifying that worker as an independent contractor, which was particularly relevant to our growing gig economy in the United States. Workers who provide services on demand, freelance workers, and other types of workers who work on maybe a flexible or temporary basis. I always think of drivers for ride-sharing apps or food delivery apps, but there are many other types of workers that fall into this category. The Super Shuttle decision was actually overruled in 2023 by a new majority of the NLRB appointed by President Biden in a decision called the Atlantic Opera Inc. And this decision rolled back the emphasis that was placed on entrepreneurial opportunity under the prior administration and imposed a current test that considers entrepreneurial opportunity as only a small part of the many factors looking at this analysis, assessing the totality of the circumstances. And notably, current board member, as Beth Ann mentioned, Marvin Kaplan, who President Trump currently appointed as the chair of the NLRB, dissented in the Atlantic Opera decision. And he argued that the old test under Super Shuttle was more consistent with the NLRA, more consistent with court precedent and common law, and arguing for a return to that standard. So if we were to guess as to what's going to happen, President Trump is widely expected to nominate 2 more members to the NLRB who, together with Kaplan, will form a new majority that may very well seek to overturn the current Atlantic Opera test and revert back to the Super Shuttle standard. So let's move on to the next slide, please. Under the current test, the Atlantic Opera test, the NLRB looks at a host of factors here that you can look here that all analyze the specific working relationship between the employer and the worker to determine whether an appropriate independent contractor status exists. And these factors include the extent of control over the workers and how they perform their work, with more control making it more likely that the NLRB will consider the worker an employee. And similarly, whether the work is performed under the direction or the supervision of the employer's managers, whether the worker is engaged in a distinct occupation that's commonly performed by independent contractors, or similarly, if the work requires specialized skills or specialized training that's indicative of a contractor who's in the business for themselves. The factor of whether the employer provides tools, equipment, facilities like they do for regular employees, the length of the working relationship with a longer time period suggesting an employer rather than a contractor status, the method of payment, whether it's similar to the way that employees are paid, or whether a contractor might get paid by the job or a flat rate, whether the work is integral to the employer's regular business. So, for example, if a contractor is doing the same job that's typically performed by the employer's employees, the intention of the parties, is there a written agreement that describes the intent of the parties to form an independent contractor relationship? And finally, whether the worker is engaged in an independent business. And this is one factor that looks at a couple of different things, including whether the worker has a realistic ability to work for other companies, whether the worker has any sort of ownership interest in the work that they perform, if the worker has control over important business decisions, and most importantly for our discussion today, the current test does consider a worker's entrepreneurial opportunity, but only as one element of this one factor, is the worker engaged in an independent business factor. And so if forcing it to be an element of only this one factor significantly reduces the importance of any entrepreneurial opportunity available to a worker and increases the likelihood that any such opportunity is going to be deemed outweighed by any of the other factors here, such as control. Right? And so under this current Atlantic Opera test, no one factor is determinative. Though the NLRB under Biden has often focused on the degree of control that's exerted by an employer over the manner in which the worker performs their work, but can consider any of the others depending on the specific circumstances of the case. If we could move on to the next slide, please. So the Super Shuttle test issued under President Trump's first administration, it's not dramatically different from the current test. And in fact, it largely considers the same factors, right? And the outcome is still, will still largely turn on the specific facts of the case. But the key difference is the way that the NLRB treats the facts indicative of entrepreneurial opportunity. And I keep saying this word, but what I mean by entrepreneurial opportunity is the extent to which a worker has an opportunity for economic gain or loss, depending on the worker's own choices or their ability to structure their work. So the example I often give is a food delivery driver that works through a mobile app who's able to set their own schedule, accept or reject specific deliveries, and therefore control whether they work more or less and make more or less money. That sort of worker would have a fairly significant amount of entrepreneurial opportunity. And under the Super Shuttle test, at least, there would be a pretty good case to be made that they were an independent contractor, depending, of course, on the other factors as well. Under this Super Shuttle test, the NLRB considers any facts concerning entrepreneurial opportunity as the animating principle by which to evaluate everything else, all of the other factors, with the premise being that workers who have significant and entrepreneurial opportunity are more likely to be deemed independent contractors than employees, which is, again, particularly important because it's fairly rare that you're going to have a case where all of the factors come out one way, right? More often than not, there's going to be a mix, with some factors supporting an employee classification and some factors supporting a contractor classification. And so that brings me to the next slide, please. I think the bottom line here is that if the NLRB reverts back to the Super Shuttle test, the role of a worker's entrepreneurial opportunity will become more significant to the analysis, particularly if there are bunch of different factors that come out in different ways. And it'll make it much easier to classify workers as independent contractors, excluded from the purview of the NLRB. And so workers, employers may be asking, what do we do now in light of this guidance? And it's important to note that the Atlantic Opera test remains the law for now, at least for the time being. And that's not going to change until President Trump appoints at least one more member to the NLRB, that appointment's confirmed by the Senate, and then that new majority of the NLRB finds a case that addresses independent contractor issues and then chooses, if it so chooses, to overturn the Atlantic Opera precedent. And so what I'm saying is the current test under Atlantic Opera will likely stay in effect for quite some time yet, though it may very well be that the NLRB, under the direction of President Trump's new general counsel, will deprioritize the enforcement of Biden-era rules, like the broader emphasis on an employee classification, the test under Atlantic Opera. But on a final note, I want to stress that it's also important for employers who are trying to navigate this area to understand that the NLRB is just one piece of the puzzle. Regardless of what the NLRB does or chooses not to do, other agencies and other courts in various jurisdictions, they all have their own separate tests for, or many of them have their own separate tests for classifying independent contractors. For example, the U.S. Department of Labor uses the 6-factor economic realities test. The IRS has its own 3-factor test for purposes of tax withholding and payments. Some jurisdictions like California use the very stringent ABC test to classify workers as independent contractors under state law purposes, and so forth. There are many others, and so employers need to consider not only the NLRB rules, but also whether their current classifications comply with federal and local rules that are applicable to the employees in whatever jurisdictions those employees work.
And I'll just highlight there, Carl, I think that's a really great point. Here in Colorado, the Colorado Department of Labor and Employment actually has information sharing agreements with multiple state and federal agencies, and they care deeply about worker classification. But if they see anything that looks wrong to them, even though they're applying a different standard, they're going to share that information with these other agencies so that they can each do their own independent investigation. So I know Allison has some really interesting stuff to talk to you guys about in relation to handbooks, but I'll highlight one of my clients was being audited by 3 different agencies that were applying 3 different tests all at the same time. So even though we might not get as much enforcement for a little while by the board, even though the standard doesn't change, I think this is one that has to be high up on smart employers' lists to ensure they're in compliance and understand what's expected of them, of the variety of agencies they're going to be dealing with in their particular jurisdiction.
Thank you, Beth Ann and Carl. I do actually just want to add in one thing with respect to that, which is it's not just agencies, but for example, in New York, you actually have different interpretations among case law as well under the different courts. If you want to be confused even more, then you're looking at agencies, laws, various agencies, laws, and common law, which basically case law that may all define independent contractors in a different manner. So the CLE code word is NLRB 2025. I'll repeat that. NLRB 2025. Okay, time for our next poll question. So my company updates its handbook every year, every 2 to 3 years, every 4 or more years, or we're supposed to have a handbook. Okay, impressive. Okay, 40% of you say every year. I see 36% say every 2 to 3 years, which is probably about the average that I see among my clients. And for those of you in the 8% that didn't know that you were supposed to have a handbook, you definitely should. And frankly, regardless of the size of your company and how many employees you have. Okay, so if we can move to the next slide. Okay, so the first thing that I want to talk about is employee handbooks. For those of you who just answered that you update your handbook on an annual basis, you might be saying to yourself, I literally just did this and now what do I have to do? But the answer is for right now, you actually don't have to do very much because not much has changed yet from the prior year or years. In fact, most of what I'm going to talk to you about today are with respect to handbooks and agreements, are legal requirements that came into place over the last few years. So they probably won't come as much of a surprise to you. But if you update your handbook less frequently, or if you're in the process of doing your current 2025 review, you do need to take note of where things stand. First, I want to put this all into context. Most of what I'm going to be talking to you about today is actually grounded in Section 7 rights under the National Labor Relations Act. And this section basically just codifies the right of non-supervisory and non-managerial employees, those employees who are not covered by the Act, to engage in protected concerted activity. That is, they have the right to engage in activity that discusses, promotes, or challenges the terms and conditions of their employment. Under the Act, an employer cannot interfere, restrain, or coerce employees in the exercise of these rights. And that's all important background as to where we get to with these handbooks and these agreements. For those of you who may be tuning out because you heard National Labor Relations Act and you think that it doesn't apply to you because you don't have a unionized workforce, tune back in. Because these Section 7 rights apply to all non-supervisory and non-managerial employees, not just those that are covered by a union. So where do things stand now? The leading case with respect to workplace rules and policies in general is called Stericycle. And for those of you who joined us last time, if you remember at the beginning of my section, I said you might have some whiplash, and that's going to happen again when we talk about Stericycle. There had been board precedent in the past, but then in 2023, the board basically adopted an entirely new framework that went back to kind of pre-Trump administration, first Trump administration era. It adopted a new framework for evaluating whether workplace policies impede on employee Section 7 rights. And this changed from the prior position that allowed more flexibility for employers for rules that basically furthered a legitimate business interest. So this main case is called Stericycle, and it did basically three main things. It imposes an additional burden by challenging work rules that could reasonably be considered coercive, even if there's a non-coercive intent or interpretation behind the rule. And what this means is that rules that on their face can be seen to have a chilling effect will be presumptively violative of the National Labor Relations Act. It really views this from the perspective of the employee and not the employer's interest. What it then does is it shifts the burden. It says this presumption that it's violative of the NLRA, even if it just could be seen as having a coercive effect, is that presumption is rebuttable by the employer only if the employer can prove that it advances a legitimate and substantial business interest and that they couldn't have advanced that interest in a more narrowly tailored way. The third thing that it does is that it does away with this precedent that came from a prior main case, which is a Boeing case from the NLRB. What Boeing basically did was establish buckets or categories of rules that were essentially per se lawful. It said rules like about confidentiality, non-disparagement, outside employment. We're going to go ahead and say that these advance employer interests, and so you could do it. Stericycle got rid of that. It said we're not going to have any categorical rules that are presumptively lawful or categorically lawful. Instead, we're going to look at rules on a case-by-case basis to determine if they individually interfere with Section 7 rights. So looking ahead, for now, there's been no indication or real discussion as to whether or not the second Trump administration's NLRB is going to chip away at this Stericycle standard and perhaps revert back to the more employer-friendly Boeing standard. And Boeing was the standard during Trump's first administration. In fact, for now, as Beth Ann discussed, the NLRB can't really do much of anything because it doesn't have a quorum. But we can read the tea leaves a little bit. Then board member Kaplan, who's now the chairman and is still on the board, dissented in Stericycle and was heavily critical of the board's approach. And he said that basically that Stericycle upset the balance between employer and employee rights and gave dispositive weight to employees. So this could really forecast a return to the Boeing era standard. the more employer-friendly standard going forward. So what are you supposed to do now? First, take a look at this list of policies that I have on the slide. These are the policies that we see the most issues on because they tend to include language that could be interpreted as interfering with Section 7 rights. Some of them, like personal conduct, conflicts of interest, confidentiality, and investigations, were actually even specifically addressed and shut down in Stericycle. So if you haven't already reviewed your policies in light of Stericycle, you should do that now. I want to be very clear though, this doesn't mean that you can't have these policies. It just means that these policies need to be analyzed for the balance of employee versus employer rights and whether there is something that could be seen as chilling. For those of you with union employees, you'll also want to cross-reference your policies with a collective bargaining agreement and make sure that you're not abridging any rights under a collective bargaining agreement. One way to do this is also to include a statement in the handbook at the beginning that states that to the extent that there's a conflict between the documents, the CBA is the governing document for those who are covered by it. This is also why training is so important. The rule, even as written, can be a violation of the NLRA, meaning just having something in writing that could potentially have a chilling effect can be a violation. But you can hedge your risk of exposure on this if they're implemented properly. And so it's important to train your supervisors and managers on what these policies say and how to actually properly apply them. A common question I get is, well, can't I just put in a Section 7 disclaimer? That's a disclaimer that says that nothing in here is intended to interfere with your rights under Section 7. The cases make clear that this is probably not enough. In fact, frankly, it's really never been enough. We all put it in there. Everyone likes it. It makes them feel better, but it won't do the trick. Certainly, at least not right now. Okay, if we can go to the next slide, please. Okay. The board was very active in 2023. So in addition to what we discussed, which impacted everyday workplace rules, it also issued a few decisions and guidance that will impact your everyday agreements with employees. The first was McLaren-Macomb, which came down in February 2023, which calls into question most employers' standard non-disparagement and confidentiality provisions and severance agreements provided to non-supervisory employees. Most of these talk about the fact that you can't keep the terms and underlying facts and circumstances of a separation confidential. I'm sorry, you have to keep those terms confidential, and that you can't disparage an employer. Now, many of these provisions have actually already been under attack under certain state laws, but then the NLRB issued this wide-ranging decision that said that these provisions, as written, interfere with Section 7 rights. It also said that conditioning severance on signing an agreement with these provisions could be a violation of Section 8A1, which is the one that prevents you from interfering or coercing an employee in their exercise of these rights. So in McLaren-Macomb, the confidentiality provision said that the employee agreed to keep the terms of the agreement confidential and not disclose them to a third party, subject to a few exceptions. And the board said that with respect to the non-disparagement provision, it was problematic because it prevented employees from making public statements about the workplace that are central to their Section 7 rights, and that employees should be able to assert these complaints against an employer if they violated the act or to assist fellow employees in doing so. And with respect to the confidentiality provision, the board took issue with the fact that it precluded employees from disclosing the existence of a potentially unlawful provision, which would chill employees from filing an unfair labor practice charge or participating in an NLRB investigation. The board's main point in all of this was basically like, you can't ask an employee to choose between benefits, as in severance, and their Section 7 rights. That's unfair. The formal general counsel also issued a memo calling into question the use of non-competes, non-solicits, and stay or pay agreements. For those of you who don't know, stay or pay agreements basically are provisions or agreements that say, you know, if we pay for tuition reimbursement or sign-on bonuses or anything like that, you have to stay for X period of time. And if you don't stay for that period of time, you have to pay it all back. The board said this has an impact on employee mobility, which is really which undergirds kind of union organizing and other concerted activity. It'll mean that employees have greater difficulty replacing their lost income if they're discharged for exercising their statutory rights. Their bargaining power is undermined, and their solidarity and kind of social ties with others that lead to improvements in working conditions will also be undermined. The board also, in its guidance memo, said any violation of this can come with some serious monetary exposure, including, for example, if somebody gets a new job, the former employer being responsible for making up the difference in the wages. So where do we go from here? Again, we can take some practical guidance from these agreements from what the NLRB under the first Trump administration said, which largely held that these agreements were generally permissible unless there were other circumstances that called them into question, like a wrongful discriminatory discharge, or anti-union animus. But here's some practical guidance. Look at these provisions. Here's what's going to happen, I think. As things start to shift back to pre-Trump precedent, you're also going to start to see an increase in union activity. And this might seem a little counterintuitive, but the idea here is that if employees are going to start to lose some of their rights under the law and guidance, they're going to turn to unions to help to protect them as much as possible. And this is going to put some additional scrutiny on these items. Consider what your languages actually prohibit. For example, for non-disclosure, how much can an employee not disclose? Is it just the severance amount? Is it all the terms of the agreement? Is it the underlying facts and circumstances of their discharge? For your non-disparagement, does it apply to anything about the company, or is it just false statements about the company? And make sure you have a good severance clause. The general counsel's memo actually indicated that while a violative provision would be problematic, it would only require employers then to strike that provision. It wouldn't render the entire agreement null and void. But you always want to make sure you have a good severance clause in your documents to ensure that. You should be prepared for the pendulum to swing the other way. There are kind of two main thoughts about this, or main schools of thoughts about this. The first is that you make the changes now that align with what the current regime says and avoid any liability. The second is that you take the risk and make your agreements broad and basically optimistic and hopeful on the theory that once the pendulum does swing, you will have the most coverage possible. Which avenue you choose is really a business decision and is based on how much risk you want to assume. And to analyze that risk, we recommend that you speak with legal counsel.
Allison, if I may very quickly kind of jump in here, I get these questions all the time, particularly regarding to confidentiality provisions. I had a client recently who wanted to take a more aggressive approach to confidentiality provisions in their employment agreements for their sales team. And we put together a very robust confidentiality provision for the supervisors on that team who are not subject to the restrictions that Allison outlined because they're supervisors, not employees under the NLRA. And then we put together a separate provision for the non-supervisors that focused specifically on protecting the company's trade secrets and proprietary company information. We also included language in there that made clear that none of this prohibits employees from discussing their wages or conditions of employment. And as Allison noted, we also included a strong severability provision in there. So there are tactics, there are ways to address this that employers can implement and not forego confidentiality provisions altogether. I just want to hop in there. But I feel like in the interest of time, let's move on from my example there. I think Taylor has the next section of the analysis.
Yeah, thanks, Carl. So again, hi, everyone. I would like to segue now into our unionized employers, or those who presume that they might become unionized employers, given what Allison just stated. And can we put up the poll question, please? Thank you. So the question is, when are you negotiating a successor or initial collective bargaining agreement? Currently, within the next 6 months, within the next 4 years, or are you thinking, what even is a CBA? And just a reminder, as the polls are coming in, if you have a question, please use the Q&A box below, and I'm going to shorten my presentation just a little to ensure that we get to your questions. So the poll questions coming in. Okay, a few of you are really wondering, what is a CBA? A CBA is short for a collective bargaining agreement. It is an agreement that is negotiated between a union who has been elected by the employer's employees to be a union representative and to bargain over the terms and conditions of their employment. And it seems that a few of you are, it's kind of a nice range. Some are currently, some are the next 6 months, and naturally some are within the next 4 years. So thank you. If you could take the poll down, please. So, and if we could go to the next slide. So thank you. So I ask about when everyone's negotiating their upcoming collective bargaining agreement, because literally just at the end of the term this past December, there is a significant change in an employer's right to unilaterally change certain terms and conditions of employment. In December 10th, to be more specific, the board issued the Endurance Environmental Solutions, which reinstated a former standard, which is the clear and unmistakable waiver. So you may be wondering, what does this have to do with anything? Well, if you are a employer that has a unionized workforce, when you're negotiating a CBA, a collective bargaining agreement, there's this term called mandatory bargaining versus effects bargaining. So a unionized employer generally is not allowed to make unilateral changes to mandatory subjects of bargaining, which include wages, hours, and other significant terms and conditions of employment, without first providing the union notice and an opportunity to bargain over that change. The clear and unmistakable waiver standard takes it one step further. It says that the board will not allow, or under the board decision, employers are not allowed to unilaterally make a change to a term and condition of employment unless it was explicitly waived in the collective bargaining decision. So it needs to be unequivocally and explicitly expressed that there's a mutual intention amongst the parties that the employer has a right to unilaterally change an employment term. This is significant, especially for our folks who are in the middle of negotiating their contracts right now. Think about the ways in which your management rights clause does or does not cover certain terms and conditions that you want to unilaterally have the right to change. If we could go to the next slide, please. So I also just want to point out, while I'm in the middle of everything, if people have questions and we're running a little bit over, please stay on. We're going to answer your questions. So back to the presentation. As you can tell from our presentation already, there's a lot of flip-flopping, and we continue on that. We plan on that continuing going forward with this Trump administration. We anticipate that there will be a return to what's called the contract coverage standard. So it's more broad. It allows employers more leeway and argument to say that this was not explicitly, this was not explicitly covered by the parties' collective bargaining agreement. Therefore, the employer has a right to unilaterally change a term and condition. This standard looks at the plain language of the agreement. And the board will consider based on some evidence, but really if there was an agreement amongst the parties that this had to be a term that was discussed and bargained over. Again, more leeway for the employer and less stringent standard. So right now, when it comes to mandatory subjects of bargaining, employers should carefully review their collective bargaining agreements to confirm the presence of clear and specific language waiving the union's right to bargain over certain decisions at issue prior to making any unilateral change. Where a collective bargaining agreement does not include explicit language that waives the union's rights to bargain over a specific issue, employers presently should proceed with caution. Again, this decision will likely flip-flop back to the contract coverage standard. So our guidance today is that when negotiating these collective bargaining agreements, especially these initial collective bargaining agreements, seeking a robust management rights clause is crucial. You really want to keep a clear and clean record of the negotiations so you can refer back to bargaining history. This has been used time and time again in my practice, where we've looked back to what our bargaining notes stated about whether or not a union has waived their right to bargain over a particular issue. Further, not only is it important to focus on a robust management rights clause, but there are ways within certain provisions of the collective bargaining agreement, separate from the management rights clause, that you want to preserve your management right. It could be just adding an extra sentence to clarify what the employer wants the right to do, as opposed to just giving it up, essentially, especially when we're under this current standard. And obviously, that was a bit truncated. I also want to point out, that this contract coverage standard is currently being applied by the DC Circuit, the First Circuit, the Second Circuit, and the Seventh Circuit. So this is the preferred standard right now amongst the circuit courts. And so that's something to note, that likely this board, once there is a quorum, will use the circuit court's decisions to justify their return back to the contract coverage standard. And with that, I would like to send it on over to Beth Ann to start us off with some questions.
Awesome. Thank you, Taylor. And actually, Taylor started the question and answer. For those of you who are not able to stick around, Gabby, if we can go forward one slide. I want to remind you all of the CLE code word before you jump off, in case you are here for CLE credit and not just to listen to awesome labor law nerds talk about the things we love. And that is NLRB 2025. Again, one last time, NLRB 2025. Now we did, first, thank you for listening. We got some really great questions this time around and some great audience participation. Thank you for doing our polls. We enjoyed it, whether you did or not. And as I was alluding to, Taylor actually answered the last question that came in with the end of her presentation, but just in case she has anything to add to it, that question was, does not the DC Circuit, where all NLRB decisions are reviewable, hold to the contract coverage principle and rejects the clear and mistakable? Anything to add, Taylor?
Just one thing to add. So while yes, all NLRB decisions can be appealed to the DC Circuit, the NLRB decision could also be appealed to the circuit court of the jurisdiction where the case was originally filed. So for example, if there was a case arising out of Region 2 in New York City, and then that decision got appealed to the board, that board decision could be appealed in either the Second Circuit or the DC Circuit. So just to clarify.
Awesome. Thank you, Taylor. And then I do have a question here for Allison. It relates to the handbooks. Someone was surprised that their company does not have a handbook, but was curious whether having standalone policies, which is their preferred practice, meets your advice in relation to having a handbook.
Yeah, this is actually not an uncommon practice, particularly with people who, with companies who maintain their policies online. They actually just maintain them as separate documents. It's one and the same. So maintaining standalone policies or are basically if you stapled them together and they would be a handbook, then anything that I said in terms of the principles applies to your standalone policies as well.
Awesome. And I will just add, because this comes up a lot with my clients, and I litigate. So if you are in the unfortunate situation of being an employer who ends up sued, one of my favorite things about a handbook is it really gives us something to point to say, this is where we send our employees to get guidance. So whether you're on the internal intranet, like Allison was alluding to, or have a paper old school handbook, being able to show that your employees have access to and are actually directed to, and Gold Star have actually read the policies that you're implementing, I think that's really what we're looking for. It's not supposed to be empty paper. We want it to be something where we can say we conveyed to our employees what our standards and expectations are, what we give them, and what we expect of them in return. Okay, so to finish us off, Carl, we do have a couple questions going back to the independent contractor standard. And I think I'll do the easy one first and then the slightly more nuanced one. Relative to tools and equipment, is it that 1099s should provide their own, and that if you supply them, it leans towards W-2 status?
Yeah, absolutely. So if you provide any sort of equipment, any sort of tools, you do the same for employees. So you're essentially treating your worker the way you would treat a regular employee. So that would suggest, or be one of the factors that would suggest an employee status.
Beautiful. And that really does cue up our last question that came in that we want to get to before we let anybody who stuck around go. And that is, can you talk about how employers should navigate the difference between the independent contractor standard for the NLRB, whether or not it changes, versus for other requirements at the state level, such as what's expected of you under workers' comp, unemployment, state minimum wage, etc.?
Yeah, that's a great question, and something that comes up all the time. I touched on it a little bit at the end of my presentation. It may very well be that you have a worker where one law applies and they would be properly classified as an independent contractor, but then under a more stringent test, they might be classified as an employee. And so first of all, you want to be aware of all the different tests and the various different factors and how they apply in that specific circumstance, because it really does factor on the specific facts of that working relationship. But as a general rule of thumb for risk-averse employers, when multiple different laws apply to the same worker, it may make sense to take the most restrictive law and abide by that law, err on the side of classifying as an employee rather than a contractor, because there is a presumption under a lot of these that that is an employment relationship rather than a contract relationship. And you just really want to be careful if you're pushing the boundaries there. I would consult with legal counsel before going out on a limb and classifying your workers as independent contractors. Oh, Beth Ann, you're muted.
Thank you. I tried to be respectful and mute myself, and I'm glad that you caught that. So thank you, everybody, for attending today. And for those of you who are still here, if you look in the chat, you can see the CLE submission form, as well as a link to the other presentations as part of this series that are occurring. You won't be hearing from us as part of this series again on the NLRB, but I'm sure there'll be another excuse for us to come talk to you again later. Thanks again for coming, and enjoy the rest of your week.